Hi everybody, it's Andy, and welcome again to my office in Los Altos, California. I'm an attorney licensed to practice law in California as well as New York. In this video, we are going to talk about California hourly fee agreements. Stay tuned. Okay everyone, so as I said in the intro, this video is going to be about California hourly fee agreements. Even though it's California specific, a lot of the principles I'm going to describe probably will apply in other US states also, possibly other countries as well. Hourly fee agreements, I think, for attorneys is actually quite popular. It's quite common. So I would imagine that a lot of what I say here will apply to other countries and other states also. I can't promise that, of course, can't verify that because I haven't checked. But basically, if you're outside California and you're watching this video, take what I say here with a grain of salt and do your own research as always. So that said, then a while ago I put out two videos about contingency fee agreements. There's one video about contingency fee agreements generally. I'm going to try to play that right over here and link it down below in the description for you. But that video basically goes over things like, contingency fee agreements in personal injury cases, product liability cases, what those agreements have to have. And then I also put out another video about contingency fee agreements in California divorce cases, specifically family law cases. I'm going to play that one down over here. This one's probably going to be less applicable, like it's a very narrowly tailored sort of video, but I have had people ask that quite a bit in divorce sort of scenarios. So I figured, hey, might as well put out a video on it. So because I've gone over contingency fee agreements already, or contingency fee arrangements already, this video about hourly fee arrangements hopefully will kind of complete the trifecta, I guess, and bring the discussion completely back to the starting point. Towards the end of this video, I'm going to talk about flat fee agreements also. Just for whatever reason, flat fee agreements and flat fee agreements and hourly fee agreements, oftentimes clients will bring them up at the same time. So it makes sense to talk about them here. So anyway, hopefully that made sense. By the name, I guess, I'm sort of hoping that hourly fee agreements, most people will be able to guess that basically means certain amount of dollars per hour, 500, 1,000, etc. Certain number of dollars equals 1 hour of work by this particular attorney. So it might be $300 per hour, for example, and that will buy you 1 hour of the attorney's time to do whatever, meetings in court, phone calls, emails, etc. So that said, then I guess the fee agreement, the actual contract that you sign with your attorney, number one, you should have one. Number two, you should basically know that contract forwards and backwards to find out what specifically your attorney is charging you for. So, I guess the safest thing is to assume that your attorney, if you're paying him or her by the hour, is charging you for everything. Every meeting, every paper reviewed, every phone call returned, every email that they send you, you will be paying for that. It's generally pretty, I don't know what the word is here, risky, I guess. It doesn't really make any sense if you have your attorney on an hourly fee agreement to assume that your attorney will do X, Y, Z, or basically anything for you for free. Your attorney, if he or she's cool and nice and stuff, they will say, hey, because this was a really short email or really short call or something, I'm not going to charge you for it. However, if you I guess it should be the exception rather than the rule. If you have an attorney on an hourly fee agreement, generally the safest thing to do is assume that you have to pay them for every little thing. So, yeah, I guess hopefully that made sense. I'm going to also describe what a retainer is, sometimes called an evergreen retainer. So a retainer, different than a retainer agreement, a retainer is something that basically is a lump sum of money that you have to pay your attorney pay your attorney initially when he or she is going to go on to an hourly fee arrangement. So you might have heard, okay, well, it's going to be $300 per hour and $3,000 up front, for instance. So that retainer agreement, the retainer amount rather, generally is something that, I'll be honest with you, it does turn a lot of people off because they just don't have $5,000 sitting around, $3,000 sitting around, and so on. But The reason why attorneys ask for that, most every attorney that I know who does fee agreements or hourly fee agreements, me included, will generally ask for a retainer amount up front. The reason is because, it's, I guess, historically lawyers have always done it that way. Number two is that it actually reduces the risk of non-payment for the attorney, so that's kind of why lawyers ask for it. They do it because, number one, they can. Number two, they historically have always done it. Yeah. So the thing is, the retainer amount, once it's actually depleted, the attorney will ask for more, and then the client pays more, and the whole kind of cycle starts all over again. So that's how it's supposed to work. I'm going to address a little bit of something here about fee or flat fee arrangements as well. So what I just kind of described, where it's like, once the retainer amount is depleted, the client, will need to pay more. They don't have to pay more. So the thing is, a lot of times clients will think that, oh, okay, well, if I commit to paying $300 per hour, I have to pay that indefinitely. And I just can't afford that. I don't have the budget for it. Oh, hey, Mr. Attorney or Miss Attorney, can we do a flat fee agreement instead? I kind of mentioned at the beginning of the video that I was going to talk about flat fee kind of arrangements as well. And this is why they often come up in the same conversation. So a flat fee arrangement generally is going to be something where the lawyer agrees to do X, for you in order, in exchange for $5,000, $10,000, in order for some fixed amount of money that is specified at the beginning. I can understand why the client would want that. Like I said, it's basically beneficial for budgeting purposes. I think a lot of clients, however, don't quite understand that they have the choice to not pay an additional retainer amount once the initial retainer amount's depleted. So, for instance, if you commit to paying $300 per hour, you're not paying that for the remainder of the case. If you decide to stop paying, you as the client have that right. But it is something where basically your attorney has the right to also not represent you anymore, to basically stop working. Yeah, so it's not something where, if you commit to paying $300, you're not paying that forever. Yeah, so because a lot of times I think clients think that they have to pay forever, they will ask for a flat fee instead. This is why a flat fee in general, I think, doesn't work for the attorney. It also doesn't work for the client either. And here's why. So, I guess there's no way to kind of say this politely. Court cases take a while. There's a lot of uncertainty. There's a lot of variability. It is almost impossible to predict how long a court case will take. The only kind of reliable prediction, I guess, to be honest, is that it will take longer than you expect in almost every instance. The court might have its own kind of thoughts and feelings. The other lawyer might cause problems. The facts of the situation might change, etc. So I, as the plaintiff's attorney, for example, generally I'm not going to be able to predict how long or how much work a case involves, a court case involves. So because of that, I'm not going to commit to a fixed fee with the client, because if I commit to, say, $10,000 and that's based on an estimation of 20 hours worth of work, if it goes to, say, 50 hours worth of work or 100 hours worth of work, and I'm locked into a flat fee, I, as the attorney, basically am screwed financially, right? I'm doing all this work and not making any money, or I'm making very, very little money, and it just really does not work for me. So because of that, most attorneys that I know who will do a flat fee, they generally will do it only for non-litigation cases, for example. If they just want documents, drafted, lawyers a lot of times will do flat fees for those. But for any type of court case, generally lawyers will not do them for a flat fee because there's all this variability, unpredictability involved. If you do run into an attorney who actually does do any type of court stuff for a flat fee basis, I would caution you to kind of look at, okay, well, what are the assumptions what are the assumptions that go into what this flat fee amount is? So I'll give you an example, I guess. So let's say that the attorney or the client hires me to represent them on this type of court case, for instance. And let's say hypothetically that it is something that I am willing to do on a flat fee basis. In order to protect me as the attorney, I generally have to quote a much higher rate. I have to assume that the court will take a long time to do it. I have to assume that the other attorney will be a jerk and cause a lot of, inconvenience and drag the case out, etc. So I'm going to assume that the case will take a lot more work than I can really kind of estimate here, I guess, kind of at the outset. Because it's, I kind of expect that it will take a lot of work, I basically have to inflate my hourly fee to make sure that I make enough money kind of at the end of the case. So I guess if you want a flat fee for a litigation case, my kind of feeling is that those flat fees generally are going to be more. They're going to be more, they're going to be like, $10, $15, $20,000 when realistically they might only have to be $4,000 or $5,000. Because litigation is unpredictable, a flat fee generally will be inflated, I think at least. So that's why I think at least flat fees generally are not worth it. I'm kind of disappointed, I guess, that a lot of clients don't really realize that. The saving grace here, I guess, for the client is that they will, they can pay by the hour. They can pay $3,000 up front, let's say. When that $3,000 is used up, they don't have to pay an additional $3,000. They can, if they want their attorney to continue working. But if they don't, the attorney's basically going to say, okay, I'm not going to force you, but because you're not going to pay, my contract, my retainer agreement with you allows me to withdraw. Yeah. So I mean, it's not, I guess, it's not personal when clients do that. So the thing is, clients, they have their own financial needs also. So the thing is, if a client has to, I guess, quit, or fire the attorney because they can't afford the attorney anymore, and they go to an attorney that has less experience and as a result charges less. If that's like satisfactory for the attorney, satisfactory for the client, that's perfectly fine. It's happened to me before. It's happened to every attorney before. It's not something that we take personally. There's just sometimes clients, for whatever reason, they need different representation. That's just part of how the real world sort of works. So hopefully that kind of made sense. So hourly fee agreements, what they are, what retainers are, generally better to kind of avoid the whole flat fee scenario, I guess, in my opinion. I'm going to leave you with two last points about hourly fee agreements and my kind of hope or recommendation to you that if you have a situation where you're sort of reluctant to cough up $3,000 or $5,000 or something to hire an attorney on an hourly fee scenario or hourly fee sort of arrangement, generally better to find some way to make it work. If you have the money and you just don't want to, my recommendation is generally not the best way to handle it. And I'll give you some examples. So first example actually relates to medicine. So I guess hopefully all of you have medical insurance, but if you don't, and one day you wake up with like a pain in your side or a pain in your stomach or something, you might think, hey, I really should go to the doctor. But then you think, hey, I don't have insurance. It's going to cost me a fortune. I'll just take some ibuprofen or I'll stay in bed and sleep it off or something. So hopefully that, that works. The pain goes away or it heals itself or something. But there are probably quite a few scenarios where doing that doesn't work. The pain doesn't go away. The pain gets worse. You start bleeding from, various orifices, etc. So if you wait until the situation gets really bad and then you go to the doctor might tell you, hey, dude, had you come to me sooner, I would have been able to solve this for you pretty easily. But now, hey, there's no cure, or, maybe there is a cure, but it's going to cost, 20 times more than it would have had you come to me sooner. It's going to require a whole bunch of surgery. It's going to require years of physical therapy. Basically, because you waited to resolve a problem, the problem got a lot worse. That applies in law also, for sure. One example that comes to mind is domestic violence restraining order trials in California. A lot of times people who have restraining orders on them, they're the ones who are, the restrained party. A lot of times they will think that they can do these DVRO trials themselves. Some of them do not a bad job. I've seen transcripts from trials that people have done themselves. Other times, though, people have done a horrible job. They're trying their best, but they just are going down the wrong track completely. And they just, basically, had they spent a little bit of money at the very beginning to kind of have somebody kind of point them in the right direction, and then they would have gone down that track, I think they would have ended up better. But the reason why it's important, I guess, is that a domestic violence restraining order trial basically is a one-shot deal. If you do it right and you win, great. But if you don't do it right because of some stupid mistake that you would not have made had somebody just told you, you basically are stuck. There is no chance to basically do it over again. And the consequences of that, you might lose your custody of your kids. You might have a permanent, like a restraining order on your record that might disqualify you from jobs in the future, etc. Bad stuff can happen. It's basically better to spend a little bit of money now, I think, to kind of get in the right kind of mindset, I guess, to kind of analyze your situation, correctly at the very beginning, so you go down the right path and not the wrong one. So hopefully that made sense. So it is better to basically hire some help at the beginning to kind of prevent a small problem from becoming a much bigger one. So that's point number one. Point number two is sort of related to that, in that if you wait to hire an attorney rather, and you decide to do a lot of your case yourself, you might have a serious problem, kind of like the DVRO trial scenario, where you really screw it up. You can't go back and kind of do it over again. You basically put yourself in a really big hole for no reason. That's one scenario. The second scenario, which happens a lot also, but it is not, it's more annoying versus bad. If you do a lot of, if you do a lot of your case yourself, let's say you spend a lot of time and effort and, kind of brain power trying to fill out forms in a divorce case, for example, in California. You spend all this time, you spend all this effort, and then, finally you get to a point where you think that you need to hire some professional help. You do that, and then your attorney spends 2 minutes, let's say, looking over all these forms that, you spent the last 4 months working on. The attorney looks at it in 2 minutes, says, dude, you did all these wrong. This is not what this is for. This is wrong. No, this form, you don't use it. This form, you didn't serve it properly. This form, it's not complete, etc. So if your attorney has done that, hopefully these forms are stuff that you can basically, just redo. It's no harm, no foul. It's just time and effort that you've wasted. But you can redo the forms and everything's fine. Sometimes you can't redo the forms, and that is more like the first scenario, where you basically put yourself in a hole for no particular reason, just because you wanted to save some money on attorney's fees. Yeah. So hopefully that made sense. This video, we ended up going over a lot, but hourly fee agreements, what they are, what attorneys, what retainer amounts are. We talked about flat fees also, generally why they're not really beneficial for the attorney, why they're not beneficial for the client either. The big kind of takeaway there, I think, is that a lot of clients don't realize that they are not committed to pay the hourly fee forever. If they choose not to pay, that's their right, but the attorney generally will basically choose to stop working also. Yeah, and it is generally better by multiple measures to bite the bullet sooner and pay the attorney's fees, pay the retainer amount, $5,000, let's say, to pay that sooner if you can in any way do it. It will make your scenario kind of easier to deal with generally, because a small problem will not become a gigantic one. So, like I said, hopefully that made sense, and thanks for sticking with me to the end of the video. And if you have stuck with me to the very end, go ahead, comment, share, like, subscribe, all that social media stuff. And I will talk to you guys next time. Thanks.